Now we're going to be moving into the second half of this session, which Professor Deere and Abigail will introduce in a second, have entitled Feminist Perspectives on Carceral Logics and Restorative Justice. I've had to rehearse pronouncing that word many times this morning. So just to give a brief introduction of both of our speakers, immediately to my left is Sarah Deere. She is a citizen of the Muskogee Creek Nation of Oklahoma and a professor at the University of Kansas. Ending violence against women is her life's goal. Her 2015 book, Beginning and End of Rape, Confronting Sexual Violence in Native America, is the culmination of over 25 years of work with survivors, working with survivors, and has received several awards, including the Best First Book Award from the Native American Indigenous Studies Association. A lawyer by training and an advocate in practice, Deere's scholarship focuses on the intersection of federal and Indian law and victims' rights, using indigenous feminist principles as a framework. Deere is a co-author of 4 textbooks on tribal law and has been published in a wide variety of law journals. Her work to end violence against Native women has received national recognition from the American Bar Association and the Department of Justice. She has testified before Congress on 2 occasions regarding violence against Native women and was appointed by Attorney General Eric Holder to chair a federal advisory committee on sexual violence in Indian country. Professor Deere was named a MacArthur Foundation Fellow in 2014. She currently teaches at the University of Kansas, her alma mater, where she holds a joint appointment in Women, Gender, and Sexuality Studies in the School of Public Affairs and Administration. Professor Deere is also the Chief Justice for the Prairie Island Indian Community Court of Appeals. And to her left is Abigail Barefoot, a third-year doctoral student in Women, Gender, and Sexuality Studies at the University of Kansas. Her research explores community and activist-based restorative justice programs and their ability to address cases of sexual violence. In particular, Abigail examines how survivors understand and articulate their experiences of sexual violence and how justice is defined within and beyond carceral frameworks through restorative justice practices. She is the 2018-2019 recipient of the University of Kansas Social Justice Research Award and has been published in the Internet Journal of Restorative Justice and the Journal of Critical Thought and Praxis. Please join me in welcoming our next speaker.
Thank you, everyone. I have the plague. So if you come up to this microphone later, you might want to spray something. I apologize in advance for that. I may have a full-on sneeze here, but I brought some Kleenex, so I should be okay. First of all, I just want to convey my deep appreciation for the invitation, and particularly the opportunity of a lifetime to meet Judge Aquilina and Tonia. Your incredible story has moved me from afar, and now I feel like I have been moved from near. I think it is absolutely vital that in all of our conversations about the criminal justice system, we do center on the survivors of crime. I was a rape crisis advocate for 6 years before I became a law student, and in all that time, I don't think I've ever seen such a profound victim impact experience as I did when I watched the Nassar sentencing. I was deeply moved by the ability of each victim to have a chance to confront the perpetrator and share their own truth about how his crimes had impacted them. I am pleased to be starting our next panel, which I share with my colleague from the Women, Gender, and Sexuality Studies Department, PhD student Abigail Barefoot. As feminist scholars, we are particularly interested in how gender and sexuality come into the picture whenever we begin thinking about the appropriate response to sexual violence. And then for Abby and I, the term restorative justice means something slightly different than perhaps what we've been talking about today so far. So for us, restorative justice, it means something slightly different than sustained victim impact statements, which could be categorized as restorative, but to us are not the restorative systems that we talk about in our work. So we define this restorative justice as an alternative to the mainstream adversarial criminal justice system. Restorative justice systems, as Abigail will explain, de-emphasizes carceral punishments in favor of having the offenders accept responsibility through consensual and constructive dialogue. Now, we do not suggest that such a model would be appropriate in the case of Nassar. However, we are interested in exploring what restorative justice means in the context of violent crime. Abigail will begin our discussion by describing feminist concerns about the mainstream criminal justice system and its focus on carceral logics. I will follow Abigail by describing some of the feminist concerns that I have about the most well-known restorative justice programs. Now, in the final section of our paper, which will be written, we are going to seek some common ground and seek possibilities of addressing both of our feminist concerns in developing a feminist analysis of systems that may work for sexual assault outside the context of the mainstream criminal justice system. So I'll give it to Abby.
Thank you, Sarah, for your opening remarks, and thank you, organizers of the symposium, for having us. Like Sarah mentioned, I'm going to discuss some of the critiques raised by feminists about using carceral frameworks to address sexual violence, particularly how they may cause further harm to survivors. I'm then going to briefly connect this to my own research, which looks at using restorative justice in cases of sexual violence outside of the criminal justice system. So despite feminist activism and policy reforms to have the criminal justice system take sexual assault seriously, sexual violence remains underreported and underprosecuted. In the United States, 1 in 3 women and 1 in 6 men will experience some form of sexual violence in their lifetime. Yet for reasons discussed below, sexual assault is less likely to be prosecuted compared to other crimes. According to one study, of the 40% of sexual assault cases that were brought to police, only half resulted in arrest, and only 58% of prosecuted cases resulted in a conviction. Under one estimate, 15 out of 16 sexual assault survivors in the United States can expect no significant accountability from the criminal justice system to address the actions of their perpetrator. Scholars refer to this discrepancy between reported instances of rape, arrest, and convictions as the sexual assault justice gap, and leads to the perspective that nothing really changes when it comes to the problems survivors face when engaging with the criminal justice system. Despite this gap, society tells survivors that the law will provide justice and accountability, even though sometimes it causes more harm. In response to the issues addressed above and growing concerns about mass incarceration and increasingly punitive measures, many academics and activists are critically interrogating what is broadly defined as carceral feminism, approaches to sexual violence. Rather than a label claimed by some feminists, such as liberal feminist or socialist feminist, carceral feminism refers to a growing discourse about the dangers of relying on the state's punitive power to advance women's liberation. For carceral feminists, the criminal justice system acts as the center of sexual assault prevention, and the primary and most efficient solutions to ending sexual violence requires increased policing, tougher laws and prosecution, and imprisonment. Thus, social justice becomes reconceptualized as criminal justice. Carceral feminists believe that criminal punishment serves a symbolic purpose by sending the message that society should take sexual violence seriously, which it should. As sexual violence intensifies and legitimizes discrimination, carceral feminists argue that harsher punishments and increased penalties for sexual violence are needed to provide victims with justice and send the message that rape and sexual assault will not be tolerated. Within this framework, anti-violence advocates engage in collaboration with law enforcement, rely on state funding, and argue that violence against women is a crime as well as a social issue. While this approach does offer some survivor support and it does help society take sexual violence seriously, it's not without its limitation. When safety and protection are defined through state function, it often works to individualize safety for a few while further increasing control over individuals' lives, particularly people of color. Scholars such as Beth Ritchie and Dean Spade argue that the collaboration of the feminist anti-violent movement with the increasingly punitive justice system occurs at the expense of poor women of color and sexual minorities. Ritchie states that while the anti-violence movement works to improve arrest policies, everyday safety in communities of color is being threatened by more aggressive policing, which has resulted in increased use of force, mass incarceration, and police brutality. At the same time, social welfare policies have become increasingly more punitive by working towards controlling families through narrow definitions of family, work, and gender roles, which can impact access to welfare, custody of children, or lead to incarceration itself. Even policies that we design to help survivors of gender-based violence, such as mandatory arrest in the cases of domestic violence, has disproportionately and negatively impact women of color. Mandatory arrest policies resulted in an expanded oppressive police presence that led to women of color and lesbians being more likely to be arrested than their white and heterosexual peers, even when they themselves were the victim initiating call for police assistance. In addition, collaboration with law enforcement to increase prosecution rates of sexual violence ignores how women and individuals with marginalized identities, such as women of color, LGBTQ individuals, and those who might engage in prostitution and sex work, have experienced sexual violence from police officers themselves. These offenses include unwarranted strip searches, sexual harassment, and sexual assault. While activists and news reports have brought increased attention to the issue of police officers' sexual misconduct, the problem remains understudied with limited empirical data. However, scholarship does highlight that law enforcement offenders target the most vulnerable, which does include women of color, transgender and gender nonconforming individuals, and victims of sexual violence themselves. And this is to reduce the risk that their victims will report the misconduct. And in 2010, the Cato Institute National Police Misconduct Statistics and Reporting Project found that out of 4,861 unique reports of police misconduct tracked that year, officer-involved sexual misconduct was the second most common form of misconduct reported. Another study found that 548 reported cases of police officers arrested for sexual misconduct between 2005 and 2007. However, the number of instances is likely higher as sexual misconducts are hidden offenses that often go unreported, and survivors face barriers when trying to report. Who do you report to when the person that you're supposed to report to was the one who caused the assault in the first place? For marginalized communities, a history of abusive encounters with the criminal justice system leads to a distrust and fear of the system that is supposed to protect them. In this way, an increase of arrest rates and law enforcement involvement has not led to gender-based violence decreasing, and instead leads to more violence for some communities. Thus, when addressing the issue of sexual violence, we must include an intersectional lens that takes into consideration race, class, gender, and sexuality. In doing so, it's clear that an increase in punitive measures resulting from carceral feminist frameworks has not resulted in social stability and safety for some communities, but rather increased violence against marginalized communities. Critics of carceral feminism argue that focusing on punitive measures strays from the broader socialist goals of the anti-violence advocates within the feminist movement of the 1970s and produces an individualized, unequal variant of justice. As the nature of the criminal justice system individualizes acts of violence to focus on individual cases of breaking the law, it often erases structural inequalities such as exploitative economic conditions, sexism, and other systemic oppressions from the cause of violence. As the anti-violence movement shifts away from collective efforts towards larger social change, it increasingly focuses on individualistic efforts to improve the lives of individual survivors. Again, this is not an inherently negative response. However, to respond to the needs of survivors, there rose a wave of professionalization and bureaucratization around responding to gender-based violence. These responses not only became part of the state's social control and punitive systems, which are more likely to target marginalized communities, but it produced a certain type of discourse around victimhood, in which rape creates broken, traumatized survivors who are in need of care and the protective authority of the criminal justice system. And again, this might align with some survivors. But for some survivors, they might not see themselves reflected within this narrow definition of victimhood, and it doesn't really address the full scope of their needs. The focus on survivors by feminist advocacy and crime victim movements disconnected issues of gender rights from civil rights has contributed to the victim as the idealized political subject. This image has allowed political actors to prioritize punishment over rehabilitation of offenders and increase penal policies through vengeance and ritualized rage about crime. Thus, criminal justice responses to sexual violence place the blame for violence on individual bad men, which justifies a coercive and punitive state reaction, while obscuring the role of structural oppression and the justice system's own role in reproducing violence. At the same time, women are told to take on a neoliberal model of risk management to protect themselves from potential rape, and then they're blamed for not taking necessary precaution when violence does occur, as demonstrated through rape myth adherence. It is well acknowledged that police, prosecutors, and juries upholding rape myths can influence the outcome of rape cases within all stages of the criminal justice system. The law, in particular, due to its adversarial setup, supports these assumptions about what constitutes rape by questioning survivors' narratives and decisions and making their experiences main suspect. Survivors often feel on trial themselves, in which their motive and character become a critical issue in deciding whether or not the sexual encounter was consensual, a fabrication, or actual rape. While the inclusion of rape shield laws are designed to deprive the jury of precisely the type of information that promotes rape myths, scholars argue that these laws are often worked around or just flat out ignored with few, if any, consequences for the lawyers who violate them. Assumptions about who is the victim and what counts as rape intersect with sexual, racial, and class-based stereotype, in which being a genuine victim correlates with being respectable, heterosexual, being white, and actively resisting the assault. This leads to sexual assaults against minority women not being underreported, underinvestigated, and underprosecuted when compared to white women. A 2001 study found that prosecutors were 4.5 times more likely to file charges if the victim was white compared to black victims. This discrepancy is partly due to women of color being stereotyped as aggressive, violent, deviant, or hypersexual, which could also be related to those stereotypes towards LGBTQ individuals. As Barbara Hudson argues, minority individuals are more likely to be seen as suitable enemies than ideal victims within the criminal justice system, preventing them from receiving equal and sympathetic treatment within the system. Issues of racism, sexism, heterosexism, form ideas about what a real rape situation looks like, who should be considered a real victim and a real perpetrator. The widespread belief of rape myths have led rape victims prior to reporting to consider whether or not they think police, prosecutors, or juries will believe them, which helps lead to this low reporting rate. While relying on the carceral state is often presented as the primary tool for eliminating sexual violence, when survivors use carceral frameworks to respond to their assault, they face further victimization. Through relying on punitive mechanisms, feminists have failed to produce a fully intersectional approach to sexual violence and instead have applied this one-size-fits-all model of justice that individualizes and decontextualizes sexual violence from system of oppression. When addressing sexual violence, we must look beyond the criminal justice system by focusing on women's particular and different needs and experiences. Otherwise, the responding public policy and interventions will be inadequate to meet the needs of women of color and other marginalized groups. Analyzing the outcomes of carceral feminist approaches demonstrates that issues of sexual violence cannot easily be fixed through reforms or through harsher punishments. Many scholars and activists have called for more attention to restorative justice, both within and outside of the criminal justice system, to better address the needs of all survivors. However, there's little research that discusses when and why survivors see restorative justice as equipped to address their needs in ways that the criminal justice system cannot, and conversely, when do survivors see restorative justice as causing more harm? Within my own work as a doctoral student here at KU in the Department of Women, Gender, and Sexuality Studies, I look at activist communities in San Francisco who are working outside of the law and outside of the criminal justice system more broadly to address the issue of sexual violence. Critical of many of the points I addressed earlier, these communities and the survivors within them want a different avenue for justice, one that still provides accountability and addresses the harm caused, but not necessarily incarceration as the main form of punishment. As studies show, for many survivors, they just want to be heard, they want to be believed, they want the offender to admit what they did was wrong, say they're sorry, and have some form of accountability that it won't happen again. This is not to say that this is not to say that some survivors do not want harsher punishments or longer sentences, but for the survivors I look at, the law is not the best option. They fear that due to their sexual assault circumstances, they won't be believed, or they've had bad experiences with the police and don't feel like their experience will be taken seriously. Or they actually care about the offender, and despite their behavior, they just want them to get help. I recognize that not all survivors want this type of restorative justice approach, and I also recognize that all cases are not suitable for restorative justice, such as the case of Larry Nassar or Brock Turner. However, if we want to help all survivors of sexual violence, we need to be critical about the limitations of the criminal justice system and the structural inequalities embedded in it, and think critically about alternative forms of justice, if that's what the survivor wants. However, as Sarah will explain, we also need to be critical about how restorative justice is used for sexual assault, or it may also harm survivors.
Thank you, Abby. It's been a real pleasure to work with you on this project. So I come at this issue, I kind of come to this issue with a bunch of different hats on. Like I came here to KU Law School with the sole goal of becoming a sex crimes prosecutor, and then like I never did that. So, I'm also a tribal member. I am the Chief Justice of a tribal court. And so I've been really puzzled for the past few years about how we think about restorative justice in the context of tribal communities and tribal courts. Tribes can have some flexibility and freedom in terms of how they think about resolution to crime. Many, if not most, of tribal governments today operate with a very westernized legal system, one that was really foisted on us and forced on us, as if you want to be a civilized people, you must have the black robe and the gavel and do those things. There's been a push in the last, say, 20 or 30 years of saying that's not working for our community. And so what we need to do is reinvigorate these traditional methods of dispute resolution that are more meaningful to our community and more in keeping with respect for all involved. That theory, that idea, I have no issue with. I think that restorative justice could be a very useful technique, although sometimes when you talk about it in traditional tribal communities, you're not talking about restorative justice, you're talking more about traditional justice, because restorative is what we did before, so it's just our traditional way of doing things. However, in seeking somebody who was who wanted to be a rape crisis or sex crimes prosecutor, sorry, the cold medicine is like right here, right now. I've developed a number of real concerns about the literature. Now, I don't mean to suggest that restorative justice in the tribal context can't work. I think it can work for almost any kind of crime. I think it can be ideal for juvenile offenders, for probate matters, for non-conflict, non-violent divorces. I think there's a whole slew of things where we can do it better than the Western system. But when it comes to sexual violence, the literature has given me quite a bit of concern. So let me give you an example. One of the most well-known restorative justice programs that's widely publicized in this nation is Navajo Nation. Navajo Nation has a peacemaking system which operates as a parallel to their Western law and order system. At any time during a Western law and order conflict, that case can be transferred to peacemaking, but it can also be transferred back. And so they work in tandem, and people consent to go into peacemaking. Attorneys are not allowed in peacemaking. Traditional spiritual leaders are working in a ceremonial way to help people come to a resolution. I started reading about sexual assault being used in that context, and it deeply disturbed me. So I wanted to share with you just a few passages here. So this was the beginning. This actually came from a book called Navajo Peacemaking, which was sort of a handbook, I guess, for how it works. So an Indian Health Service psychologist who specialized in the treatment of sex offenders called the Office of the Chief Justice for assistance. So here you have a psychologist calling the Chief Justice of the court. And this psychologist said to the Chief Justice, we have this special program for sex offenders, and he reported himself to it. This perpetrator dropped his denial, and the IHS psychologist felt that peacemaking would be an effective means of dealing with his sexual abuse. No, his sexual abuse. The word victim appears nowhere in this at all. We don't even know how old the victim is, how many there are, but would be effective means of dealing with his sexual abuse. Arrangements were made for a referral to peacemaking with protections of confidentiality, given the likelihood that the Federal Bureau of Investigation did not know about the underlying crime. For me, again, coming from that trained as a prosecutor mindset, is outraged that they would keep this a secret just so the guy wouldn't get arrested. And again, there's no mention of the victim anywhere in this passage whatsoever. Here's another case in the Navajo Peacemaking book. The first thing the author asserts is that peacemaking in sexual abuse cases is controversial because it's clouded by anger. And as a survivor myself, and as somebody who's worked with hundreds of survivors, I think our anger is very well placed. And I think that anger is justified, and while it may not be the solution, it should be respected that anger should be respected. So here he's already sort of saying, well, these survivors are too angry. But then he goes on to say, he had a student who was a lawyer who was learning Navajo law, preparing for the Navajo bar exam. And one of the lawyers said, you know, we've got a situation in which the child is being sexually abused, but we don't know if the abuser is the father or the maternal grandmother, which I thought was kind of an odd juxtaposition. How do you, but that's what they said. The lawyer didn't know if the abuser was the child's father or the maternal grandmother. And so he said, how is peacemaking going to help here? And so the teacher, who also said that we were too angry, explained that he'd seen a similar case where they got together with the peacemaker in the hopes that somebody would confess. Well, nobody confessed. So the lawyer said, well, what would happen if neither of them admitted of it? There was no confession. In that case, the family isolated the child from both people. And that child was never alone with either. And the lawyer expressed his amazement at the simplicity of the approach and said he'd been so focused on the notion of identifying and punishing the wrongdoer that he had not thought simply about protecting the child. I have so much to unpack about this. And in fact, I do. I have a book where I skewer this, and there are many Navajo people that are mad at me about it. And I'm not suggesting again that peacemaking wouldn't work in any plethora of other kinds of conflict. But the idea that simply isolating this child from two possible perpetrators is serving that child, is serving the community in any sustained way is deeply troubling to me. Now, I'm not saying that all Navajo peacemakers work with this construct, but this is the literature that's out there, and it is entirely offender-centered. So that's why I get concerned about it. There was one other passage I wanted to share with you. This comes from Canada. There's a community called Hollow Water, and in this community, it's very isolated. They discovered that the sexual abuse rate in this community was upwards of 90%. In other words, 90% of the children in this village were being sexually assaulted. So there was an effort to try to figure out how do we resolve this without sending every single adult in this community to jail. The problem I have is that it operates on a premise that the only way that an abused person can rebuild his or her life is to expose his or her pain in the abuser's presence. That is an incredible burden to put on the shoulders of a victim to say, if I don't express this in the right way and you don't hear me and you don't understand my way, then I've failed the system. It puts the onus on the victim to find the way to justice. And there's also a contract that both the victim and the perpetrator have to sign together. One of the things that they have to sign is basically an understanding that sending people to prison is a form of genocide. So imagine you're a 10-year-old child who's been sexually abused by your great uncle, and the system is telling you either go through this peacemaking system or participate in genocide by sending your people to jail. Okay, so yeah, and then we don't know if there's really a willing participant in that situation. So, I am intrigued because I am a tribal citizen and a tribal judge of looking at ways of doing things that are better than the current Western law and order. We're not trapped by the precedent of most Western law and order. We can be creative. We can come up with solutions that are relevant to our culture, relevant to our ceremonies, relevant to our history. But we have to be very, very careful that we're not using those systems to be offender-centered and to leave the victims the ones that have the burden on their shoulder to make sure that that offender learns what he needs to learn. I believe there are feminist ways, feminist interventions in these kinds of peacemaking literature that are desperately needed. At the same time, respecting and honoring that peacemaking may be absolutely the best way to go for many other kinds of crimes. So that's where I am with it.
Mr. Cassell, if you wouldn't mind joining us up here, we do have time for a few questions. So does anyone have any questions for any of the three speakers?
So I hear you talking about how, I like what you said about that those things seem offender-based, because I think that's the kind of criminal justice system we have. You said you see possibilities for feminist practices to enter into those. What does that look like where we are including the victim and centering on the victim, but yet not, how do we balance that fine line of not forcing the victim to be the educator in that restorative justice practice? So, like, do you have ideas? Yeah, kind of to you.
No. that's the rest of my career, figuring it out. You know, one thing that has been suggested to me is that tribes are able to develop certain kinds of panels for adjudicatory questions, and there can be a panel of grandmothers in that community that help inform the court about what women go through, and that may take some of the onus off of the victim to express what sexual assault does, not just to one person, but to our entire community. And rather than putting it on her shoulders, you know, bringing a panel of expert grandmothers who know the language and the culture and the tradition to be able to say, here's what we need to see happen next. That's something we don't necessarily have in the Western system, so we could do that. Some of our tribes could do that.
Thank you.
So I can also address that. In some of the work that I've been looking at, it's rethinking what we mean by community. So if restorative justice brings together not only the victim and the offender, but the community, thinking about, well, our communities are not perfect. They hold terrible beliefs based in racism, sexism, homophobia, the whole 9 yards. But thinking about, what about if our community was people who supported the survivor understand sexual violence and domestic violence and have them be there to facilitate the conversation, to prepare both parties separately, and making sure that that the case is suitable for restorative justice. So if it seems like the offender is not taking any responsibility, it's probably not going to be the best option for a restorative justice case. And also thinking about, are there ways to do restorative justice where they don't have to interact with each other? Could someone, similar to a victim impact statement, tell her story for the survivor to the offender, or write a letter and have the offender respond without the two of them being in the same room?
Yeah, and I think we also have to remember that one of the fatal flaws in restorative justice literature that I've read is there's no fact-finding mechanism.
Yeah.
So if you have an offender in deep denial, says, I didn't touch her, I wasn't there that night, I don't know what she's talking about, how do you restore that? And you do need an adjudication, in my mind, at that point.
Yeah, so I guess I have a question for everyone. But in terms of looking at restorative justice, I know you're talking about tribal court and you're talking about Western law. Have you looked at and are there restorative justice mechanisms in other cultures, in Latin American cultures, in African cultures, and what do those look like? Sorry.
My research has primarily focused on those within the United States and Canada, so I can't speak broadly, but we could look at larger contexts such as like the Truth and Reconciliation, excuse me. But I am not as familiar with practices outside of the United States. Any more questions?
One for you, Abigail. In your research, why did you find that women of color, how did you find the women of color and lesbians were disproportionately, you said, arrested when they were reporting crimes? What's
Yeah, so some of this is due to stereotypes that we have, particularly looking at within lesbian relationships. So you have two women, one of them is being abusive to the other one. Oftentimes what they would find is the person who looked more manly, so what we would consider to be more butch, regardless of whether they were the victim or the offender, would be arrested. Because they thought, oh, here's this person looking more masculine, they obviously must be the abuser, when in reality that could have been the victim. But they just assumed that due to these stereotypes that they were the the abuser. And similarly, oftentimes in communities of color, what would happen is they would just arrest both the victim and the perpetrator. So both people would be like, oh, this is a spat between two people, she fought back, therefore we're going to arrest both of you. But you don't necessarily see that as much within heterosexual white couples that are experiencing domestic violence. They assume that the man is responsible. If the woman, usually in the case, was fighting back, totally necessary, we shouldn't send her. So it's a lot of stereotypes and assumptions based off of the idea that certain communities are more dysfunctional and therefore need to be sent away.
All right. If there aren't any more questions, I will say that we can have one more round of applause for our thank you all for being here this morning. Please rejoin us at 12:40. We'll come back from our lunch break. So for the speakers, there is lunch on the 5th floor in the rice room, and then we'll all